Attorney General Mallory Shanahan on behalf of the state.
Good morning, Your Honor. William Fetke from the offices of Fetke and Petty on behalf of Mr. DiMura, who's here on my left, Judge.
All right, very good. So I had all your submissions. Thank you very much, Mr. Fetke. I had a
welcome.
chance to read them, and as well as Ms. Shanahan, thank you very much for your submissions. I was able to review those also.
Thank you.
So, Ms. Shanahan, why don't you take a seat? Mr. Fetke?
Yes, Judge.
Yeah.
Just bear with me, Judge. I know we're under time constraints.
No, you're not.
Okay.
No time constraints. We need to...
Okay, all right. Judge, I did, thank you for acknowledging that you've received the numerous character letters that I filed on my client's behalf. I did file a letter brief, Judge, dated January 25th, 2021. And Judge, I want to make one correction to that, if you don't mind.
No.
I think I was pushing the envelope when I was citing my mitigating factors. And on page 4, I asked you to consider factor number 4. There were substantial grounds tending to excuse, that Judge, eliminate that. That. It's really not applicable in this case. And I think I was just pushing. In addition to that, Judge, there were additions and/or corrections to the pre-sentence report. I don't know whether you got them.
Yes, I got those.
You got them.
Thank you for doing those in advance.
Okay. So Judge, here's my pitch. And before I begin, I know that the state has individuals that they want to speak at Mr. DiMura's sentencing. Judge, I object to anyone speaking who is not a victim of count 1, the count that my client pled guilty to. I just want that for the record.
Okay. But the restitution agreement, though, incorporates those victims, though, right?
That's correct, Judge, it does.
All right, so I'm going to allow everyone to speak.
Okay, all right. Well, Judge, as I indicated in my, do you mind if I sit, Your Honor?
No, I can see, are you uncomfortable?
No, not at all. It's the first time I've had to put a shirt and tie on in quite a while. And I don't like this mask, but what are we going to do?
You're going to have to stand up because you don't have any gray hair.
Absolutely. Although I'm getting some.
Thank you. Better gray than nay, Judge.
Yeah.
So, with respect to the aggravating factors, Judge, as I indicated in my sentencing brief, I would suggest that aggravating factor number 9 applies, and that the following mitigating factors apply. Number 2, that he didn't contemplate that his conduct would cause or threaten serious harm. Number 3, that he acted under a strong provocation, which I outlined. Number 6, that he compensated or will compensate the victims, or at least attempt to, Your Honor. Number 7, that he has no history of prior delinquency. Number 8, that the conduct was the result of circumstances unlikely to recur. Number 9, the character and attitude of Mr. DiMura indicate he is unlikely to commit another offense. Number 10, that he's particularly likely to respond affirmatively to probationary treatment. Number 11, the imprisonment of Mr. DiMura would entail excessive hardship to himself or his dependents, specifically, Judge, his wife, which we've gone over in my submissions. And number 12, the willingness of Mr. DiMura to cooperate. So I would suggest, Judge, that the mitigating factors substantially outweigh the aggravating factors. And my first request, and I'm going to have a series of them, Judge. I'm going to start at the top and work my way down. My first request is that, based upon that, as outlined in my sentencing brief, the interest of justice demands of downgrading for purposes of sentencing. And Judge, in this particular case, what I'm citing as in the interest of justice is COVID. It's COVID, Judge. My client is in his 60s.
He's 65, right?
65. He's got underlying health conditions, Your Honor. He is registered in several sites.
I was wondering if he has he had the vaccination?
No, he's as outlined in his letter, Judge. He's registered in several sites, but does not have the vaccination yet either.
Is he qualified to get it, though?
Yes, yes.
Okay, so it's just a matter of getting the site.
Judge, I'm registered on about 10 sites.
Yeah, I understand.
And you're on all the time, it's just very difficult to get a date. So I'm gonna stand, Judge, I don't feel comfortable sitting. So based upon that, Judge, my first request is that you sentence him to a period of probation. If that is not acceptable to the court, I'm asking for probation with 2C 364. If that is not acceptable to the court, Judge, I am asking that you consider sentencing him to a degree lower, to either a flat 3 or flat 4. And if that's not acceptable, come off to flat 7 to a flat 5 or a flat 6. That's the range that we have here, Judge. I want to make sure I have everything. I'm going to ask, Your Honor, that if you are going to sentence my client to a period of incarceration, that you allow him to remain out until he's able to be vaccinated.
Let me just tell you what I have done.
Go ahead.
For people that I have sentenced in your client's age group, that I have allowed them to stay out so long as there's the public health emergency. I don't, now, that will change with vaccination. So it will either be public health emergency or when he gets vaccinated, whatever occurs.
Okay.
That's what I have done in the past.
All right, Judge. Well, that's more than reasonable, Judge. The only other thing that I would ask, Your Honor, is that the plea agreement indicates that the state will take no position with respect to my client's application for ISP. I know in the past, I have asked the court to indicate on the judgment of conviction that the court has no objection, or the court has no objection to my client's entry into the ISP program. I'm going to ask you to consider that, Judge. And I know Mr. DiMura would like to say a few words.
All right, thank you, Mr. Frankie.
Do you need me to stand?
I would prefer, but if you would like to say anything, this is your opportunity, Mr. Frankie.
I just want to say, Your Honor, that the actions that I took were done because of pressures, personal pressures, professional pressures, financial pressures, and I made decisions that were wrong. I took actions that were wrong.
Hey.
Friends and
Okay,
family.
hold on, just 1 second. Let's go off the live video feed, please. Going on where the court was hearing noise from someone who was linked to this call. So that's no longer occurring. And so with that, we'll proceed with the hearing. Proceed, Mr. DiMura.
As I said, Judge, I had, like I said, pressures on a personal level, professional level, and also financial level, and I made decisions that were outright wrong. I took actions that were wrong. I hurt many people. I hurt friends and family. I apologize deeply for my actions, and I look for the opportunity to make it right, and I'll probably work the rest of my life to try to do that.
How are you going to do it?
If I have to work as many jobs
What's
as I
going to be
possibly
the
can.
nature of your work?
Right now, I don't know. I'd have to go find employment. Right now, I don't have any.
You own any property? I think so. Okay. All right, very good. Anything else you'd like to say?
No, that's it.
Okay, thank you. You can take a seat. Stay.
Thank you, Your Honor. I just wanted to address the defendant's requested downgrade of the negotiated sentence and submit that there's no facts that have been presented that demonstrate that the defendant is eligible for a downgraded sentence under the serious injustice standard. To meet that standard, the defendant must demonstrate extraordinary circumstances that make him so idiosyncratic that imprisonment would be a serious injustice overriding the need to deter others. Our Supreme Court has made clear that the
You're talking about the downgrade to probation,
That's correct.
not to the sentence in the third-degree range.
Well, for both, actually, Your Honor. Well,
Okay.
the sentence in third degree rape
Third
would be
degree
the
doesn't have that
mitigating factor.
idiosyncratic
Right, exactly.
element, right?
Yes.
So start with probation, and then I'll hear yes to the third, going down to
Okay.
the third degree.
So the court's discretion in the area of the serious injustice standard is obviously tightly circumscribed, and by definition, defendants who meet that standard are rare. And the defendant has not really presented anything to justify the court finding that he is of that rare category of defendants. With regard to the step down, I would argue that, as I argued in my sentencing memo, that the following aggravating factors apply. Aggravating factor number 1, the nature and circumstances of the
Hold
offense.
Okay.
In this case, the defendant systematically robbed the campaign accounts of almost every Democratic campaign in the borough of Middlesex for a better part of a decade. This was a long-standing and coordinated effort for the defendant to enrich himself off other people's money. This was not a mistake, it was not an accident, and it was not a one-time event. This was hundreds of different transactions of theft over the course of years. For aggravating factor 2, the harm inflicted upon the victims, we do have several victims here today and several appearing via Zoom who would like to speak to the court, and I'll let those victims describe to the court the harm that defendant has inflicted upon their lives. Aggravating factor 3, the risk of reoffense, which I think is entirely appropriate here considering...
Let's go back, I want you to go a little bit deeper into aggravating factor number 2, because you have a more
Sure.
detailed understanding of the facts of this case
Absolutely.
than I do. So explain to me in more detail why you think that applies.
Well, Your Honor, as you know, when you're considering the sentencing of a defendant, you have to consider the whole defendant, not just the crime that he has pled guilty to. So one of the other allegations in the state's case is that the defendant was running what was essentially a small Ponzi scheme in the borough of Middlesex, where he was telling people that he was investing their money when he was in fact making no investments with that money. He was telling people he had insurance for their investments when in fact he had no insurance for those investments. And the victims were giving him tens of thousands of dollars, and the defendant was just living off of that money. And he was stealing money from the political accounts that were laundered through the Felon Miller Scholarship Fund in order to pay back dividends to these investors to try and stave off.
So
Going.
the victim, and I don't have his or her first name, but I have the last name, Burrow.
Yes.
How old?
Are the boroughs?
Yeah.
I believe they're in their fifth. I have my file here. I can see if I have it exactly.
Do they know 50s? Okay. How about Anthony Vietri? Is Anthony married to Louise?
They're divorced.
They're divorced. Okay. How old? So they were in their 70s, right?
Yes, they are.
Okay.
I believe Mr. Vietri is in his
Okay.
80s.
And the Takach, I don't know how you say it, but
53 and
Okay.
50.
oh, you're gonna have to prove to me you're 50. I don't mean to make
I'll
light.
take that as a compliment.
That's what it's about. All right, very good. Okay, thank you.
Thank you, Judge. As for the risk of reoffense, I would say that this defendant took every opportunity that he had to steal money from those around him, and I would say that the risk of reoffense carries into the future. Aggravating factor 4, that a lesser sentence would depreciate the seriousness of defendant's offense because the defendant took advantage of a position of trust or confidence to commit the crime. The defendant, in count 1 that he did plead to, had the opportunity to commit the crime because he was the treasurer of each one of these political accounts. He was the treasurer of these accounts because he was trusted in the Democratic community in the town, and the people who were the candidates in these campaigns gave him total control. They didn't have access to their own bank accounts. They didn't file their own ELAC forms. They trusted the defendant to do that for him. As in all cases, the aggravating factor 9, the need to deter. And here I'd also argue aggravating factor 11, that the imposition of a fine or penalty without the condition of imprisonment could be perceived by the defendant or others as merely a part of the cost of doing business. As for mitigating factors, the state would concede 6 and 7. Defendant has agreed to restitution and he has no prior criminal activity. However, I would object to mitigating factor 2, that the defendant did not contemplate serious harm. Aggravating factor 8, that the offense was a result of circumstances unlikely to recur. Aggravating factor 9, character and attitude. And aggravating factor 10, that the defendant would respond affirmatively to probation. The state would also submit that factor 12 is inapplicable to this case. Judge, unless you have any other questions.
No.
Thank you.
Thank you very much.
May I let the victim speak at this
Sure,
point?
they can speak one, yeah, they can come up. Well, they come up one at a time. You can come up and, you could either come up, stand right there in the open area and just,
Okay, here I come.
okay, please mute. Okay, and then just please state your name.
Michelle Takash.
Okay.
Um,
Ms. Takash, I want to thank you for your letter. You obviously put a lot of time into it. And it was a very thoughtful letter, and I was impressed with it, but more importantly, it was a very touching letter.
Thank you. And I just want to say that both of my kids also wrote a letter, or all three of my kids. And I'm a little shaken right now, so I'm going to read mine, but I'm going to ask my husband to read one and my girlfriend to read the other. That from my kids.
Well, are they the ones that you submitted?
Yes.
Oh, because I read them. Why don't you just talk to me?
Okay, well, Judge, I mean,
Just tell me how the impact this has had. Tell me how
he has
the impact
destroyed my entire family, my entire family, my children's inheritance, my nephew's inheritance, a condo down the shore that is my father's legacy to leave to us. And, you know, I had conversation, I sat in his office, he sat at my table, I had conversation after conversation with him. I cried to him, and he promised me he'd make good on everything. I mean, it was just one lie after another. I worked with Mr. DiMura for many, many years, and you know what? I considered him a friend. I don't understand.
You were active in politics, right?
Yes, I ran with Mr. DiMura, well, not with him, but I ran, and I was a council person in DiMura,
Council
Middlesex.
person?
I can also say
Are
that.
you still a council person?
No, I am the Democratic chair now. I was vice chair, I've been a committee person, and I'm chair now. He's just ruined a lot of people's lives, and it's just sad. I mean, I'm still paying, you know, on loans and can't help my kids out. You know, I was hoping that he would come through with that, you know. And when the DAG's office showed up at my front door, like, I'm still having a hard time believing that this happened, because I worked for attorneys who told me that this was happening. You know, like, Michelle, like, you're stupid. You know, what do you, and I said, no, he wouldn't do that to me, over and over again. No, he wouldn't do that to me. He spoke to attorneys that I work with to get money from them. How would I think that was some kind of Ponzi scheme? You know, I thought he was being honest with me the entire time. I gave him my all when he was running. I battled for him, and he knows it. You know, I went on Facebook, I went out to, you know, do whatever he needed me to do. And, you know, I was a trusted, honest friend to him. And for him to do this to me, it really, really hurts.
Well, it was sort of the, what came through to me from reading your letter and from knowing politics was that, you know, when you're involved with campaigns and whatnot, it's an intense relationship.
Yeah.
And you came to really trust and like him.
But yes, I did.
And I just got the sense of the depth of having to deal with the depth of betrayal.
But Judge, I can also tell you that my whole relationship with him was only what he wanted to let you know.
Right.
Like, he had full control of everything. You know, I was told to make the call to the MCDO. I made the call to the MCDO. You know, I mean, I just did what I was told to do. You know, and the worst part of this whole thing is that, you know, he also had a sick mother, okay, that was going through things. And, you know, my Aunt Bridget, she's 87 years old. She's got no quality of life. She belongs in a nursing home. He had them take a reverse mortgage in which he stole the money, okay? He had my mother take a reverse mortgage, and the DAG's office tells me he didn't even have a mortgager's license when he did that. Now I have to go get an attorney. My mother maybe has lung cancer. She's going for surgery on the 23rd. My aunt is falling apart. Can't take a loan on the house because of the reverse mortgages. My aunt belongs in a nursing home. I'm battling Medicaid on a daily basis just to try and get her the care she needs to get her into a nursing home. You know, I didn't have it so easy to get my aunt into a nursing home like he did with his mother. You know, I originally thought that he stole all the money to put his mother into a nursing home. I was still giving him the benefit of the doubt. And maybe he did, I don't know. But at the end of the day, you know, there's nothing he can do or say to change any of this. You know, through COVID, we're every day, you know, we're just watching my aunt deteriorate. Can't get into, you know, can't get in and out of bed. Everything is a two-person job, me and my dad. And now my dad's sick too, because of his nerves. Lost over 70 pounds. You know, and if we had had it a little bit easier, look, me and my husband I'm 53, he's 50. One way or another, we'll overcome this. But my parents are not overcoming this. They're not. They're gonna be dead and buried. I don't know. I just, so emotional because I thought he was my friend. And people warned me about him over and over again, and I didn't believe anything. I didn't believe anything anybody said, because I like I said in my letter, I considered myself, you know, a pretty good judge of character, but I guess not. I really failed on that one.
All right, thank you very much.
Judge, I believe Anthony and Louise Vietri, who are hearing via video,
Oh,
would also
someone's
like
on video? And anyone else here in person who's gonna speak?
My husband's here, maybe.
Pretty much summed it up.
Okay, all right, so we're here, okay, so just someone on the video?
Yes.
Okay. Who's on the video, who's gonna speak?
I don't, Vanessa, maybe you want to start with
Who is on the video?
Anthony Vietri and Louise Vietri.
Anyone else?
I believe that's it.
That's it, okay. So I can see you?
Okay. Here I am, Your Honor.
I'm not seeing you yet.
Well, I'm seeing the courtroom. I see everyone.
Oh, there we go. Okay, now you're in. Okay.
Okay.
Okay, good morning, Mr. Vietri, and we also have Louise is on the call also?
Yes. She's
Can
on her
can
own.
we hear- Louise, can you say something to make sure your video's on? I mean, your audio? Yeah, your audio, I don't think your audio is on. So if you may need to go into your settings and hit internet audio, and you could do that while I speak with Mr. Vietri. Is that how you say your last name, sir, Vietri?
Yes, sir.
Okay, Mr. Vietri, I'm Judge Buca, and this is your opportunity to talk to me about the impact that the defendant's actions has had on you.
Well, it really has ruined my life to date. It really has. I have a sister who has Alzheimer's, and I'm taking care of her. And we were having, I get a little emotional now because of what he did to me and my family. But he needs to make restitution 100% to me. I mean, I can't understand it. Over $150,000, $200,000 he took from me. And I hardly got any of it back. And now I believed in him. I trusted him. I worked for him. I campaigned for him. I did everything I possibly could. This is really a tragic thing. This should happen to nobody. And I really regret knowing him right now. But my daughter said it all. And I'm sure the other people who are there will reiterate exactly what I'm saying. So I thank you for listening to me. And that's all I can emotionally say right now.
All right, thank you very much, Mr. Vietri. Ms. Vietri?
Yes.
Okay, I hear you now very clearly.
Okay. Thank
All
you.
right, very good. So I'm Judge Buca, Ms. Vietri. And what is it that you would like to say? Are you able to see me, Ms. Vietri?
No.
Yeah, Vanessa, can you turn the camera so you have a better view? Maybe not, I don't know. Let me see if I can turn it. There we go. All right, there you go.
Yeah, I see you
All
now.
right. Okay, very, very good. Okay, Ms. Fieschi, what would you like to tell me?
This man ruined my life. This man, I've been a friend of his for probably well over 35 years. He ruined me. I had nothing and he knew it. All I got was a Social Security check, which is like $1,290 now. I had a few dollars saved and I get nothing else. Within the next 3 years, I'll have to sell my home because I just don't have the money anymore. He took and took, and he knew why I did it. He knew that he would be giving me a payment every single month, and that would leave me to be able to pay my bills. And all the time, he was just taking my money I didn't have. I gave him $40,000 the first time. And the second time it was 30,000. And that was taken from the reverse mortgage. You know, I'm very upset. I live every single day with these money problems. That this, you know, it gets me so upset knowing that he walked out of my house knowing that he was taking that money for himself. That he was got, you know, I thought I was investing in something. And I was so, you know, I wanted to have this because it would give me a means of living. Well, now, you know, everything goes wrong with me. I'm going for surgery on Tuesday for nodules on my lungs, and it may be lung cancer. You know, I don't know what to say at this point. I'm just plain upset. Everything I touch seems to go wrong. This, and meanwhile, he took my money. And there was so much more that, you know, I can't even think straight right now. All I know is all I want to do is be able to live comfortably. I don't want a lot of money or anything. All I want to do is be able to live in my house with my dog. It's the only thing I have. And because of him, I'm going to lose it. I don't know what else to say, Judge.
All right, thank you very much, ma'am. But thank you very much, and good luck with everything.
Thank you.
Okay, thank you. All right. For now, I just have to make some findings, so Mr. DiMura, you can remain seated for now. Based on the pre-sentence report and the state's brief, well-written brief, thank you for that.
Thank you, Judge.
The court understands that basically this matter involves the defendant taking money from that was donated to political campaigns, transferring it to a scholarship fund, and then having those funds transferred to his own personal account. There was somewhere to like almost $190,000 that was transferred, and the scholarship fund only $7,000 was paid out. In addition, as ancillary to the actual crime that was committed, there was also allegations, and we heard from the victims, of the defendant improperly presenting himself as a financial advisor and taking control over other people's monies under the guise of that they would be invested, and in fact the monies were not invested, and in essence a Ponzi scheme was really created. And the victims in this case who have spoken really just, it's very obvious that there was a significant and meaningful betrayal and breach of a trust. And there was financial loss, which the state has specifically set forth in their sentencing memorandum as to the restitution amount. The defendant has consented to paying restitution to the victims in the total amount of approximately $83,000, as well as then there would be forfeiture of additional $163,582.93. But that forfeiture amount is to be secondary, right, to the primary, to the restitution amount. Is that right, State?
That's correct, Your Honor. We would ask that the restitution be paid in full before the forfeiture begins to be paid.
Okay. So the judgment of conviction will reflect that. The defendant, on one hand, the defendant was clearly a person who was perceived as a leader of the community, involved in youth football, baseball, councilman, and mayor. And this court has had, previously to becoming a judge, had experience in the political world. And I was always sensitive to how it was always seemed that it was easy for people to criticize those who were in politics. But on the local level, this court's overwhelming experience was the people that were involved in politics. Really, overwhelming majority of those people did so selfishly, did so for all the right reasons, just wanted to make their community better. And so Mr. DiMura presents himself to this court like so many do, that yes, there was a serious crime that was committed, but on the flip side, that is not the totality of the person. One does not get involved in politics and give the time that they have to give solely to steal from people, but rather to do good for the community. And I think it's important that the court recognize this, because especially in this day and age of cancel culture, you make a mistake, you make a serious mistake, that defines you, and there's no coming out of that. But that's really not the way that this court believes in this type of hearing it should conduct itself. Rather, in this age, fractured and divided, it's important that the courts show at time of sentencing an appropriate balance in evaluating the person. So I do recognize that in the course of your involvement with Middlesex, I am sure you did a lot of good, and your character letters confirm. The crime that was committed, though, was clearly a serious one. It was a crime that was deliberate, thought out over an extent, and occurred over a meaningful period of time. In some cases, the victims that I heard from were elderly, more susceptible to being taken advantage of. The scheme was intricate in taking from one fund, presenting it to another fund, presenting it finally then for his own personal use. So it was not only a theft, but it was also an effort to conceal the theft. So based on those facts and findings, the court finds as the aggravating factor number 2, the gravity and seriousness of the harm inflicted, especially where a couple of the victims are of advanced age. I also find aggravating factor number 4, that a lesser sentence will depreciate the seriousness of the defendant's offense because the defendant took advantage of a position of trust or confidence. And I say that it was more, not for it, he was seen as a leader in the community, and as a result of maybe his political activity that was perceived that way, but also people I think just generally saw him as a leader within the community, and he took advantage of that persona and the confidence that people then have in their leaders. And so I believe as a result of that, then aggravating factor number 4 applies. Aggravating factor number 9 applies, the need to deter this defendant and others from violating the law. And certainly the need for, in light of the amount of the money that was taken, the need for general deterrence is, the court believes, should be giving great weight, as well as the specific deterrence to Mr. DiMura. And finally, in light of the fact that this involved his professional business and the length of time that this scheme occurred, the court agrees with the state that aggravating factor number 11 does apply, that the imposition of a fine, penalty, or order of restitution without imposing a term of imprisonment would be perceived by the defendant as part of the cost of doing business. The court finds as the mitigating factors, number 6, the defendant has compensated or will compensate the victim, and hopefully that will occur. Number 7, that the defendant has no history of prior delinquency. And I actually find mitigating factor number 8 applies, that the defendant's conduct was a result of circumstances unlikely to recur in the future. My sense of the defendant is that he has he was caught in the actions. As a result of him then being caught, it caused then the emotional reaction he had was, I have to get this off my chest. I have to bring closure to this matter, and I then have to pay my debt to society, as well as subsequently then do my very best to reimburse the victims. And so I believe that in light of the long history of living a law-abiding life, and I weighed this carefully because the criminal activity did occur over a meaningful period of time, but I just believe that mitigating factor number 8 applies. I do not find that mitigating factor number 2 applies. The defendant did not contemplate this kind of a cause of serious harm. He knew that taking money from people, especially the elderly, that he knew or should have known that would cause serious harm, and that it was foreseeable that the actions that he took would result in this court having to hear the statements from the victim today. I do not find that the defendant acted under a strong provocation. This was just about his desire to take care of his own financial affairs at the expense of others. And I cannot find mitigating factor number 9, that due to and I find that that will only be told over time whether the character and attitude of the defendant indicate he's unlikely to commit another offense, because it will depend on once he pays his debt to society, then how he handles his restitution obligation will really define that. It's too early yet in this process to know whether the character and attitude of the defendant indicate that he's unlikely to commit another offense. And mitigating factor number 10 is not applicable in this case. And the court does not find the willingness of defendant to cooperate with law enforcement as being applicable in this action. So this court finds that based on balancing the aggravating factors with the mitigating factors, that in reality the aggravating factors outweigh the mitigating factors, especially with aggravating factor number 9. In light of the nature of this crime, the need to deter this defendant and others from violating the laws given special weight. So based on that, I'd ask you to rise, Mr. DiMura. So based on those findings, the court does find that the plea agreement was fair and reasonable under all the facts and circumstances of this case, and I am sentencing you as to count 1 of this indictment to the custody of the Commissioner of the New Jersey Department of Corrections for a period of 7 years. You are entitled to 1 day jail credit. There are the mandatory financial penalties, $50 violent crime, $75 safe neighborhood, $30 law enforcement. As agreed upon between the state and the defendant, there is a total restitution award of $83,000, $83,000 and some odd change. It's $83,372.82. And that is to be, according to the state's sentencing submission, it's $8,442 to Douglas and Justine Burrows, $16,965 to Anthony and Bridget Vietri, $21,265.82 to Louise Vietri, $10,000 to a developer known as with the initials MP, and $26,700 to the Middlesex Borough Democratic Organization. In addition, there would be a forfeiture of $163,582.93. Also, as part of the sentence and as part pursuant to the plea agreement, the restitution amount is to be primary, with the forfeiture to be secondary to that obligation. That the defendant forfeits any public employment, as well as the court will sign an order imposing a lifetime ban on the defendant ever having public employment in the state of New Jersey in the future. With that, that is the court's sentence, Mr. DiMura. If you're unhappy with the sentence, you have 45 days from today to file an appeal. If you cannot afford an attorney, the public defender's office can represent you in the matter. You also have 5 years from today's date to file a petition for post-conviction relief. So what I said in the beginning of the hearing, in light of the pandemic that's going on and that there is a public health emergency, I am not going to have you surrender today. But rather, what I'm going to do is I'm going to give you a surrender date. I'm going to give you 60 days from today. I believe in that period of time, let's hope that the public health emergency will resolve, but I believe in that period of time you should have your vaccination. And so, and that if for whatever reason that has not occurred and there's a good faith effort on your part to obtain a vaccine and you have not been able to obtain it, then I obviously would consider that. But you'll have to really you'll have to really make a strong effort to get your vaccination done. So Vanessa, 60 days from now for the surrender date?
April 16th.
Okay, so on April 16th, what day of the week is that, Vanessa?
It's a Friday, Judge.
Okay, so on Friday, April 16th, you were to report to the Middlesex County Jail, no later than noon. The judgment of conviction will set forth that. If for whatever reason there is a further impediment for your surrender, your attorney can communicate with his office and I'll make that decision.
Thank you, Judge.
But I believe you should be able to get your vaccine.
Judge, did you consider my request with respect to the court's position on ISP, since the state is taking no position?
I'm going to take no position on that. I will make that determination. I don't know if you're aware of this, when someone does apply for ISP, they notify the sentencing judge to see what the position was, and I'll make that decision at that time.
Okay, thank you, Judge.
Okay?
Thank you, Your Honor.
All right, thank you very much.
April 16th.
Yes, April 16th at no later than noon time. State, anything further?
Yes, Judge, I do have a copy of the consent order for the forfeiture of public employment, if you wouldn't mind signing
I could sign this, and if you can wait, I can't mark it, I'll just write in file. I'll have to make copies, I'll do that.
I appreciate that, thank you, Ron.
And just so it's clear to me, it's not clear to me what the forfeiture order reflects.
The
And-
forfeiture money
Yes,
order?
the monies, yes.
That would be the balance of the money stolen from the political
And
campaigns.
the political
They're
campaigns?
not restitution because those organizations don't exist anymore,
I see.
so instead they're a forfeiture to the
It's
state.
gonna go to the state?
Yes,
Very good, now I understand. All right. Okay, and then I believe you did then make the right decision in making the restitution amount, separating it from the restitution amount and making that primary.
yes, thank you.
That was well done. Okay,
Judge, we supplied you with an appeal form. I don't,
thank you. I have it, I will file it.
thank you, Your
Okay,
Honor.
thank you very much, everyone.
Thanks, Judge. All right, Ron. Yeah,
I'll talk to you. Go ahead.
Thank you.